This whole arena of investor-state dispute resolution, or ISDS as it's referred to, is one that has grown out of the relationships between investors going into other jurisdictions and making investments. It could be extraction, it could be energy, it could be getting your tea from Sri Lanka, for example. It's going in as a foreign entity into another country and having a commercial arrangement. The way this has been dealt with is really through a series of bilateral investment treaties which states enter into with each other. So they do that in order to provide a mechanism for their own businesses to be able to go and invest. And if an issue arises or a dispute arises, that these investment treaties then have a mechanism for resolving those disputes. It's rather than states dealing with states on behalf of their citizens, it gives recourse to the citizen, him or herself, to then to raise a dispute with a sovereign or a state. This has traditionally been dealt with through arbitration. So ultimately, an investor that felt that their rights had been infringed in some way by the state would bring an arbitration proceeding. There are various institutions that hear these types of arbitral proceedings, but the largest one, probably 80% of these cases, are handled through ICSID, and ICSID is part of the World Bank. And this is a process that was established about 50 years ago or so, and it's now a well-known and adopted process. One thing that has been missing from the ISDS system has been mediation. And it's something that CEDR, together with ICSID and the Energy Charter Treaty Organization, which is composed of about 54 states involved in the production and transport of energy, have been very keen on bringing mediation into the ISDS process. So we've worked together, we've collaborated for approximately 3 or 4 years now to bring awareness about mediation to that community, to states in particular, because they are more often not as aware of mediation as investors are. And so we've tried to raise awareness, and we've also become involved in training the mediators, because this is a very particular type of mediation where it's not purely the commercial interests, but also the sovereign interests of a state that are involved. And so the mediators have to understand the framework in which these disputes arise, and also how these disputes traditionally have been dealt with through arbitration. And so we've developed, together with ICSID and ECT, a training program which helps take mediators who are already qualified mediators, but then increase their knowledge to be able to deal with these types of investor-state disputes. Because this is a dispute with a state, and the interests of the state are not purely commercial interests. The state also has social interests, there will be political interests, there may be environmental issues that are at stake. And so when a state tries to deal with an investment issue, it will be dealing with a lot of other issues that are peripheral to the commercial dispute. And so that makes it much more difficult to try to resolve these disputes. That's why in the past many of these disputes weren't resolved. They went to arbitration. The problem with arbitration is that neither party actually really knows what the outcome is going to be, and often that outcome isn't really satisfactory, particularly for a state, because it doesn't deal with these peripheral issues, whereas mediation allows those peripheral issues to be explored and dealt with as well. In addition to that, by the time you arbitrate one of these disputes, the investment is probably no longer possible. It's really run its course, and the relationship has been damaged to a degree where that investment just will not continue. Whereas if you get this early enough through mediation, allowing the parties to resolve what that dispute might be, allows then for that investment potentially to continue. CEDR as a mediation institution is recognized globally, so it's known beyond the UK, but also in Asia, in North America, in Africa, particularly in places where these ISDS issues often arise. And so given that CEDR has this global credential, but is also known to have a high quality mediator training program, with experienced trainers, and also given the commercial background of a lot of these people, I think there was an interest to harness that expertise together then with the expertise of ICSID and ECT.